All right, so we should be live right
Yep.
now. We'll have to wait for people to start coming in. In the top left corner, you'll see live and then a timer. And next to that, you'll see how many viewers you should see, at least that. I see it. There's nobody on yet. So it
I
takes
just
two.
got a LinkedIn notice that says Pismo Ventures office hours free to attend start now. So
Yep,
it's broadcasting right now.
should be broadcasting. Yeah. Ken, do you see, do you have that eye with how many users next to it in the top left corner next to?
I see the live timer, but there's nobody
Oh,
on.
there's nothing next to it. Okay.
Mm-mm.
Okay. We now it's a waiting game.
This may be a short show. Oh,
It could be really short.
we just got a message from Abiraman. Says good morning. Good morning, Abiraman.
Now here's Abby. Hey, Abby. Good morning. Oh, that's interesting. Well, good morning, everyone. I don't know how many people is on. I This is the first time we do it in this manner, so we will see how this works. Um, First time we do it on LinkedIn, so maybe I should open LinkedIn and see how many are on because um, I think there may be already some people on LinkedIn. I just don't know. It's not showing me here how many people there are. If you are on LinkedIn, please say hi. Give us a shout so we know you are. Um, we're trying this for the first time streaming on LinkedIn, so we would appreciate your input. Yeah, Abby, thank you. I should probably open up the LinkedIn. We'll give it a minute or so before we get started. Okay, well, good morning, everyone. Again, I first time trying this, and I'm not able to tell how many people are on, but I could. Um, I know we're live. So, good morning, everyone. This is JJ Risha. I am with Pismo Ventures. Pismo Ventures is a venture studio. We help with startups from their ideation to raising capital. I've been an investor for about 15 years. and I am a serial technology entrepreneur as well. Um, I have with me Quan, Quan Nguyen from uh, Nguyen and Tarbet law firm, IP intellectual property, and Ken August from the August law firm. I'll give them a chance to introduce themselves quickly. Quan.
Hello, everybody. So thanks, JJ. I'm Quan Nguyen with Nguyen Tarbet. I'm here with my colleague Ken and JJ, as you know. So I'm a patent attorney, and Ken is a corporate business attorney. We're not PI attorney, personal injury. So we don't chase ambulance, but it's fair game that we would chase inventors and companies. So good to have everybody here, and we're looking forward to a lively conversation. Please do post, please do ask questions. We're here to answer questions, and it's going to be fun. Ken.
And good morning, everybody. It's really delightful to be here. August Law Group is a boutique law firm that specializes in corporate transactions and corporate governance matters. And one of the governance matters that we probably should talk about is we're happy to have everybody here and happy to have you ask questions. But please understand that when we give legal advice to clients, everything is specified to their particular case. So the answers here are for general information only, and there is no attorney-client relationship that is begun because of your participation in this podcast.
Thanks, Ken. Well, this is open for everybody to ask questions. I see right now there are some more people coming on. Um, maybe there is a way for me to see it. Again, first time trying this. But please go ahead and ask any questions you may have. And the questions that we'll be answering could be related to anything about strategic planning when it comes to your business, could be about intellectual property, could be about corporate law, could be about raising capital. Whatever you have, any questions you may have for your startup, for your scalable startup, we're here to answer. So please go ahead and ask your questions, and maybe while questions are being asked, we can just talk in general about a different subject. So maybe and I could start by asking questions. I'll ask Quan a quick question. Quan, tell us in general, maybe what is a patent, what is corporate right, what is copyright, and what is a trademark?
Sure. So under the umbrella of intellectual property, there are actually four categories. There is patents, there's trademark, there's copyright, and there is trade secret. So patents, basically, it covers inventions, things that do something, widgets, process, methods, codes, so on and so forth, that do something. Trademark covers a brand, a source. It recognizes, or it allows the public to recognize who the maker of the product is. And then copyright is a coverage of an expression, um, songs, storylines, things like that. Artistic expression, that is. And trade secret basically is are things that you do that would give you a commercial advantage that you don't want the public to know. In order to qualify for a trade secret, such as formulations, source codes, and things like that, you actually have to protect it in a certain way, and it's a state by state requirement. And that's basically the long and short of intellectual properties.
Quan, what's the difference between trade secrets and know-how?
So know-how could be part of a trade secret. You can have a know-how, but you can transmit it to other people, or you can make it public on the website. But when you have that know-how and you don't want other people to know it, what you want to do is you want to qualify it as a trade secret. And typically, when you think of trade secret, think of Coca-Cola, think of KFC. So for KFC, for example, they would have their secret formula in a lockbox. Actually, requires two keys to open it, and that's basically the requirement for a trade secret, is that you have to take some steps, some reasonable steps to assure that the people who are not entitled to that information will not have access to it. So that's the difference.
All right. Thank you, Quan. Ken, a question for you. When it comes to documentation, uh, when for a new company that is potentially highly scalable, they're going to raise capital. Um, what do you recommend first as where the company should maybe incorporate? Is it a C corp, LLC, LLP, and what should they do when they first start their corporation?
So that's a great question, JJ, and it's really impossible to answer as a generality because determining the type of business organization that they should be used and the location where that organization should be formed is very much dependent on the facts and circumstances of the particular company. There are certain states that are considered to be better in terms of the state practice than other states. And so, for example, you'll hear people say, well, if you're planning to become a large public company, you should look at Delaware because Delaware has the most pronounced corporate law with respect to public companies and shareholder rights. But really, you need to look at it. It also is somewhat tax driven, and everybody's tax situation is very, very different. So it's something that really needs to be considered both by the company's counsel and also their CPA working as a team.
Okay, all right. Um, some of the some I guess investors when they're looking for companies, they don't want to invest in LLCs or LLPs. Mostly, they want to invest in a corporation. Is that correct?
That's been my experience, yes. And LLPs, for example, are really just for practices that are licensed, like attorneys and other licensed occupations. So really should never be looking at that. Um, LLCs do have some advantages, and I've had discussions with investors and tried to explain where an LLC may make more sense than a corporation. But fundamentally, you can accomplish the same structure in either. So it's just a matter of understanding what everybody wants and needs and trying to be creative about it.
All right, thank you. Again, this is open for anyone to ask questions. Please feel free to ask any questions you may have. This is the first time we do this, so it's kind of new for everybody. Quan, you have a question? Go ahead.
I do. I have a question for you, JJ. So
Oh,
in terms of in terms of the investors having requirements before they invest into a company, um, do you see a dollar amount where a certain business entity needs to kick in? For example, if it's below $50,000, an LLC is fine. If it begins to reach the $100,000, $200,000, then an S corp or C corp is more requirable, more desirable. Do you see that, or do you have those requirements?
I haven't seen that based on a dollar requirement or a threshold. That has not been my experience. But in general, my experience has been through being part of Tecos Angels and investing individually in startups, is that most investors like to see a C corp. Um, one reason, and I can't remember the specific IRS, I guess, code, but is that if the investment is lost, it could be with a C corp, it could be from a tax standpoint. It would you could deduct it as ordinary tax versus as an investment, and if it's an investment, you can only deduct like $3,000 loss. But if it's a C corp, and again, I don't remember the exact IRS code for the tax, but you can deduct the entire amount, 50,000, 100,000 against normal um, tax deduction. So
Well,
that's one of the reasons.
the other thing that comes up too, JJ, is that everybody who invests is typically looking toward the exit, and a typical exit is either going to be an acquisition where the form of governance really doesn't matter as much, or a public offering. And to the extent that it's a public offering, everything has to be converted into common stock anyway. So it avoids having to go through manipulations during the course of the life of the company if the corporation is set up that way and can then exit easily.
Yep, that's very true. Um, Quan, question for you on international, uh, patents. Can you maybe talk a little bit about that and what does it require?
Of course. So international. Um, first of all, you'll hear the phrase or the expression an international patent. There is no such animal. There's no such thing. So patents are jurisdictional. Basically, what that means is that each country or each jurisdiction will have its own rules and regulations in order for a patent to go through and get granted. So typically, here we are in the United States. When we file a patent application, it is good in the United States only. And when it is granted, the rights that you get would be to prevent someone else from making, selling, and using what it is that you have patented. And also the good thing is, so the question is, well, all right, so if you only have a patent in the United States, if someone makes it over in, let's say, another country, let's say Mexico, let's say they make it over in Mexico, do you have any rights over them? The answer is no, because Mexico's got its own jurisdiction. However, as soon as they send it across state line into the United States at the border, that's where you begin to have rights over that product or over whomever it is that is trying to sneak that through, if you will. So it's protected within its border. And even if the product is made outside of the United States, in this case, they cannot sell it across into the United States. So let's say that you want to have patents in Mexico or in Canada or in Europe or in any other countries or jurisdictions. What do you do? Well, you can file directly into there, or you can file this thing called a PCT application, and then eventually springing off of a PCT application into there. And we have associates around the world to work with us on the various jurisdictions that you need to go into. Um, the um, the when you think about international filings, cost comes to mind. So what you want to make sure is to evaluate the necessity to actually file internationally into the various jurisdictions. Two things come to mind. Number one is what's your market cap in that jurisdiction? In other words, what's your market cap in, let's say, Europe, Australia, Mexico, Canada? That's your number one determinant of whether you should or should not file in there, because filing internationally is very expensive. I'll give you an example. Just filing in Europe is, just to start the process, is $15,000. To start the process in China is about $15,000, again, because of the translation in Japan and so on and so forth. It can get very, very expensive. So you want to look at the market cap. Number two is, are you going to be manufacturing in that jurisdiction? Because as you can remember, to have a patent is to be able to prevent someone from doing what you have a patent over. So if you have a patent in, let's say, Mexico, that means that you would be able to enforce a company who makes it, who manufactures it in Mexico. So you want to look at your market cap and the manufacturing capability of your product in those foreign jurisdictions.
Oh, wow. That's very interesting. So when you say market cap, you're talking about the value of that company in that jurisdiction?
I'm talking about the sales volume. Yes,
Okay.
everything along with that, because sales volume would dictate the value of the company, et cetera. It's the sales volume because look at it this way: if you don't sell a lot over in that country, why bother? Because they're most likely it's because there isn't much of a demand. If we're going to be selling, oh gosh, ski equipments in Africa, you can imagine that there wouldn't be much of a sales going on over there for ski equipment, etc.
Okay, so I'm gonna follow up on that because we run into that all the time, and so people say, "Oh, I just want to go and get a patent. I'm not gonna sell in China today, but I want to get a patent there. I'm not gonna sell in Europe, but I want to get a patent." So to prevent others from doing what I'm doing, and I'm selling only in the US because that's my initial market.
Mhm.
So is that a good strategy, or you think that
Yeah,
they should start selling there?
it's a good strategy. And one of the things that's really nice about the patent system is there's this kick the can down the road mechanism. And it allows you to have this runway to raise money while you try to maintain your rights in these foreign countries. So let's just start with the process. You file a U.S. application, and on the day that you file, you have 12 months before you need to make a decision if you want to preserve the priority date in that the priority date of the U.S. in other jurisdictions. So what you do is, so now it's 12 months down the road already. You file in the U.S., straightforward. The 12 months come around and you file this thing called a PCT, Patent Cooperation Treaty. Okay. You file this PCT, and this PCT will allow you, and it costs about $3,000. That's the government filing fees. $3,000 will then buy you another 18 months down the road. So that's a year and a half. Okay. Within that year and a half, you don't really do anything. There's really no cost that is associated with it. Now, before the 18-month or right upon the 18-month, that's your opportunity to then select members of the PCT. So members would be the European countries. It could be China, Mexico, and basically all the major industrialized countries around the world. So what you can see there is this kick the can down the road mechanism that the patent system has in place for you. So you start out with the US, you have your priority date and everything, and at the 12 month, you can spend $3,000 to buy an option, if you will, for this PCT thing, which allows you another year and a half. So altogether, you have 30 months to raise money. And the reason that people would file in, let's say, China, is sometimes, even if they don't have a market over there, and sometimes it's hard to enforce patents in China, is that it's not so much of them enforcing anything in China or Europe and Mexico and Canada and so on and so forth. It's very much so that the acquisition partner, a major corporation, looking into it, they would have the resource to enforce in those various jurisdictions. And when they buy your company, they would see that they would have the ability to have protections in those jurisdictions because you have initiated it. And that would be a good reason to invest that extra $3,000. And by the way, when you get to the 30-month period or 18 months after you file your PCT, if you can't raise money, if you don't want to, you don't have to go through with it. You just drop the whole thing, and basically you burned up $3,000. But it's worth the risk.
Wow, that's a great explanation for it. That makes a lot of sense. Ken, a question for you. When it comes to startups, what do you think are some of the biggest traps that companies fall into?
So there are a number of things that companies need to be thoughtful about when they get started. But one of the biggest traps that I've seen clients fall into has to do with raising their initial capital and really understanding the system that they have to work within in raising capital from different types of investors. People need to understand that even when you're operating with friends and family, if you sell shares of stock or other securities, you have to comply, and the compliance is really twofold, because they have to comply with federal law, which is superimposed over everything. But then every state has its own companion securities law, which is different from the federal law. And the law of the residency of the investor is the law that applies to that particular transaction. So if they raise money from 10 family members who live in 10 different states, they're actually dealing with 11 securities laws that they need to make sure they're in compliance with. And when people go through with these early fundraisings, then a misstep can come back and really hurt the company down the road when they're more advanced and they may be ready to file a registration statement with the SEC, or they may be ready to be picked up in an acquisition because it comes up in due diligence. And if there have been violations, it can sometimes destroy the ability to move forward the way that a company wants to. And the other side of that coin is that companies who set their capital table without the right advice can sometimes make decisions that lead to investors not being willing to participate with the company after the fact. So they really need to have some good advice in terms of how they figure out what they're going to sell as their fundraising security and how they're going to layer the different rounds as they move up the chain.
Wow. So if they're getting some money from their lost uncle in Chicago, or their aunt in New York, and their cousin in California, they have to deal with that.
They do have to, and they have to file a federal Form D if it's a private placement, which it typically would be. They have to file that with the SEC, and they have to make blue sky filings in each of the states where the investors reside, and they have to count the number of investors that they're bringing in a particular offering. It can get quite complicated if they go by it themselves.
Yep, I'm very, very familiar with that. I've dealt with it a few times. So what happens if they don't do it?
Well, we've got in and we've voluntarily done corrective filings. If we do an audit of a company and find that a notice that should have been filed wasn't made, we will voluntarily go in and say, we're new counsel for the company. We're just getting our arms around what's happened, but we noticed that this filing should have been made on this date, and we would like to voluntarily make it now. And I would say 99.9% of the time, the states will accept that, and there really isn't a penalty. Occasionally, they'll come back and they'll say there's an issue, but it's never as bad as it would be if the state figured out you sold a security and we're not in compliance with their securities laws, and they have to come to you. That's always a worse situation, and that's where you see these cease and desist letters going out saying, you may not sell any more securities. So that stops a company in its fundraising tracks right there, and it can be very, very egregious for the company.
Wow. Okay. All right. Quan, go ahead.
Yeah. So I'm assuming that a lot of our audience, our attendees today, are either about to raise money or are currently raising money. JJ, you're an investor and you work with a lot of investors. I wanted to get from you the trends and patterns that you see from investors. I know there's not one size fits all, but what is it that they look for when they first engage with a company to evaluate whether they're going to put their own personal money in there, or if it's a VC, their firm's money into that company? What are the major top three things that they look for? Can you speak to that so that our audience can benefit from that?
Yeah, I would say the very, very top one, which is definitely people don't think. They always think it's the idea. It's never the idea. It's always the team. So, so the investors are looking at the team to see if the team is able to execute, is able to get this company from point A to point B. And the team could be different depending on the types of company. If you're a software company, then you're going to commercialize. You're going to need to build good software, and then you're going to be able to uh, understand that how to market it, how to sell it, and how to get to your audience and to your customer. If you're a life science company, it's different because you may not commercialize. You may basically get to develop the device or the therapeutic or whatever it may be, and then sell somebody acquire you beforehand. So the team needs to be composed from a different type of individuals. But the team is really the first and foremost when it comes to startups trying to raise capital.
And that can also be a trap for the unwary as well, JJ, because a lot of people may not have the resources financially to bring in the team. And so they'll turn around and use their equity as a way of incentivizing team members to come on board, not realizing that when you pay somebody in stock from a wage compensation point of
Yep.
view, it's as though you paid them in dollars. And so the recipient has wage tax requirements, but the company also is developing an employment tax issue there, which they may not be aware of, and that can fester for a long period of time before somebody comes in and notices it, and it can be a huge financial calamity for the company.
The ramifications could be really huge. Yes, Quan.
So, Ken, that I actually just had that situation yesterday. So, a client of ours called me and he said, you know, the CFO just left, and at the very beginning, we had agreed for him to have certain equity in the company. Now he's left. What do we do? So now he's got it locked up in the cap table. Strategically, what should companies do at the very beginning? Because who knows, life delivers the unexpected. Um, what are the ways in which you can strategize and have a good CEO, CFO, talents to come in, but at the same time, not put the company at risk because who knows what life is going to deliver for you and they're going to leave?
So that's a great question, Quan. And when we work with clients in this area, we usually recommend that they don't give the equity out to individuals on a willy-nilly basis, but there be a defined plan with a certain percentage of the equity set aside as incentive compensation. And then under the plan, when individuals will come in and they'll take an executive position, or maybe they'll be on the advisory board or something, there is a very clear defined list of deliverables that are expected by the company for the equity that they're getting. And there's also typically, we would put in a buyback opportunity, so that if somebody is no longer performing and those deliverables, the company has the right to buy that equity back at its fair market value at the time that they leave. Because the worst thing that a company can have is if things go sideways with an executive and now they become a rogue shareholder, they can make your life miserable under the corporation's codes. And so you really want to have the ability to bring that equity back, put it back in the pool, and incentivize the next person that's going to come in to replace them.
So yeah, what I've seen, Quan, also is along the way, many years doing this, is really milestones. So if you reach certain milestones, then you will earn your equity would vest, and at that point could be vested. There are also there's what's called reverse vesting that I've seen along the way, especially with the founders themselves, because it's happened multiple times during the past few years, where you have two founders, they start something and one leaves, and when investors invest in the company, they actually take away some of the founding equity and put it into a reverse vesting schedule, so that if they leave, um, you can claw back some of the equity, so you can give it to new executives or people that would run the company. Otherwise, the company could die, and then the investment is lost.
That's right.
So, all right. So, what's the next one, Quan? As far as the top three, right? The second, I would say, um, it's it's the competitive, or what I call sustainable competitive advantage. So you could have a product, you could have a service, you could have a medical device, you could have, but what is your sustainable competitive advantage? And that's really important. And I'm highlighting sustainable because you could have a competitive advantage, but then let's say, which is never the case, the competitive advantage is your price. There's something in the market for X dollar, and then you get it at 50% off, and you're much cheaper, which is usually not a good competitive advantage, because price is not really um, uh, the right competitive advantage. So if that was the case, for example, that's not really sustainable, because the companies that are doing the same thing could potentially figure out a way to make it cheaper. Then the advantage is not sustainable anymore. So so the company needs, for investors, they're looking at the sustainable competitive advantage, so that they're able to say this company could potentially have a long way before someone else tries to compete with them. And of course, one of the competitive advantages is really the intellectual property. That's one big thing that could prevent others from doing this. But there are many others than just competitive advantage. Could be your marketing strategy, could be your sales strategy, could be a combination of many things that play into the sustainability. Could be just the team who's done this for a long time and they understand that they know how to get to a potential exit acquisition better than others in the marketplace. And also part of the competitive advantage is you cannot have hundreds of companies doing this. Um, if there are a dozen companies doing this, whatever, couple of dozens, that really proves there is a market. If there's hundreds, then it's probably you're in a commodity, and investors don't want to invest into a commodity type business. Again, this is for investors that look to invest into highly scalable companies.
That makes a lot of sense, JJ. So, from a sustainability standpoint, sometimes we see companies where their ability to produce their product is tied to maybe a sole source supplier of a component, or maybe a license agreement that grants them the rights and but could be terminable. How much does that play into an investor's decision when they're looking at the company?
I think it plays a big role into making that decision. But again, usually when with investors, they're looking at a company initially for, you know, half an hour, then maybe talking to them for longer and maybe doing some due diligence, and maybe we talk about that in a second. So it is important to kind of learn as much as possible at this, uh, before investing into these companies. And one important thing, kind of based on what you just said, is there are too many moving parts. So this is really one aspect. There could be multiple aspects that weigh in to make a decision. I guess Quan, maybe disappeared for a second. I'll answer his the last item. I think the last the in the top three, I would say it would be understanding who your customer is. That's really really huge, because you could have you know the best solution in the world, cure for cancer, whatever it is. If you don't understand who your customer is and how you're going to reach your customer, and how you're going to sell to your customer eventually. Um, let's see. Quan is saying he disappeared off the screen. I don't know how. Maybe turn on the camera, turn it on, then back on and off. Maybe that would help. I don't know how, Quan. Oh, he will come back. So I would say understanding the customer is really huge. So knowing knowing the customer, knowing how to reach the customer, knowing the customer acquisition costs, knowing the lifetime value of that customer. It is all part of that equation. Again, if you're a life science company, some of that may not come into play um, initially, but you still need to understand who your customer is, because whoever wants to acquire you, they're acquiring you because you have a product that someone's going to buy.
The other thing that I would add to that, JJ, is every once in a while we run across a client where they have an innovation that they've created, they've done the research and development, and they're obtaining a specific result from the work that they're doing. But they really don't understand the science behind why they're getting the result that they're getting. And I find that sometimes if companies don't put the effort and the resources into really understanding that science, it's very difficult for them to explain it to investors in a way that makes them comfortable in making an investment in the company.
I'm gonna say that's very true, especially for life science companies. They're really good scientists, doctors, physicians, PhDs, but most of the time they're not able to translate what they're doing into a story, into a real investment opportunity for investors. And this is part of really where where we come in as Pismo Ventures, where we help some of those companies, is really try to help them with getting their act together so they're able to get to a point where they're able to raise capital.
So basically, it what I'm hearing is you got to know your audience for acquisition partners who are savvy and who want, say, satisfying answer to the science. You got to be ready for that, right? And I can tell you, very interesting on the patent side of things. Sometimes we don't want to know the science, and I'll tell you why. So it has to do with this concept called obviousness at the patent office. So when you submit an application of your invention for for patenting, the patent office, they look at many things, but one of the things they look at is, okay, so got it. This thing is brand new. It has not existed in the world ever before. But then you pass that test. The next test is, well, all right, so it's never existed before, but would it be obvious to a colleague scientist to arrive at this? And typically, what scientists and engineers do is they would justify how it is that they're so smart that all the literatures, all the science support them to getting and arriving at where they are in their invention. So it's like this. Literature's out there, A, B, okay? Literature A, it exists out there. Literature B, a body of literature exists out there. Well, by golly, if you combine the literature body of A with the literature body of B, of course it would point to the literature body of C. And that's why, according to the scientists and applying for NIH or whatever it is that they're applying, NSF, that's why you should give me the money because this makes complete logical sense. A plus B should equal to C. Well, I can tell you that if a patent application were to have that information and sent to the patent office, it's dead upon arrival. It's dead upon arrival because the patent office will say, well, by golly, if you say that A plus B should equal C and everybody knows it, well, then it's obvious, no patent for you. So then, so it really depends on the audience. So sometimes they explain the science, and sometimes, well, for patenting purposes, it's one where you dance around and we don't know how it happened. We just got good results for whatever reason it is. It's good result. Don't know what the science is. There you go. One of the things that well, first of all, we have audience, we have attendees on. Is there a way that we can actually get questions from the attendees, JJ?
So that's what we've been trying to do. So I just reloaded, and there are a bunch of questions that they're not showing up on our side. So I could. There's a Quan question for you. Um, it says, does other IP like TM function in jurisdictional way like patents?
Yes. So there's this thing called Madrid Protocol. TM is a trademark, and trademark designates the source of something like Nike, like Adidas, like Coca-Cola. So you can file a trademark in the United States, and then if you would like to have the early priority date within 6 months, you can enter into the Madrid Protocol and proceed with various jurisdictions under that protocol, and still have the priority date of the trademark back in the United States. I can tell you that in trademark, the priority date, sometimes it matters, sometimes it doesn't. It can become a significant issue, but for the most part, it's the patent side of things where priority date is extremely critical. On the trademark side of things, it can be, but not necessarily so critical. So to answer the audience question, yes, there is a process in which you can go international as well. You can go outside of the Madrid Protocol and go into each jurisdiction: Mexico, China, Japan, Europe, and file your trademark separately. It just gets more expensive. The Madrid Protocol allows you to have everything under one roof, where you can spring from the Madrid Protocol into the various jurisdictions and keep it under one roof and decrease cost that way.
Quan, how much protection does putting a TM next to a claimed trademark give you?
Yeah, that's actually a really good way to claim your trademark, and you should do it regardless. So there's a difference between a TM and an R with a circle. Okay, R with a circle is registered. That means that the USPTO in the United States has given you that right, and it's all across 50 states. So a TM is a what's known as a common law right trademark, and historically, the TM is basically um, uh, uh, on the it's based on where you conduct business. So let's say that you're in the state of Arizona in Tucson, and you begin to sell, your burrito stand, and it's called Burrito ABC. Okay, and you put a TM after that. But the TM is going to give you the common law trademark rights within the radius of where you do your business. You wouldn't have, if you're in Tucson, Arizona, you're not going to have rights over New Mexico or Florida because that's way too far away and you're not doing business there. Okay, so now that's, common law rights is very regional, but nonetheless, there's something. Okay, now the registered trademark is federal. What that means is that you would have rights all over the entire 50 states. So that's the difference between the TM and the R. And what we encourage everyone to do is while they are applying for their R, they should put a TM after the brand.
And aren't there some serious consequences if you apply the R or the C registration before you've received registration or before you've applied?
Yes, that's under the category of improper acts, deception, and so on and so forth, because the federal government has not granted the registration, and one puts it on there. Same thing with patenting as well, is that it's false advertising and false patent labeling and things like that. So the patent office is an agency of the United States, and they have the rights to grant you these things. And so, same with the trademark registration. These are rights that the U.S. government grants, and so it should be used with care and propriety, not willy nilly, just write things on there because it can get one in trouble. And just on that note, when an investor looks into whether they're going to or not going to invest in a company, they do a due diligence. So, can you speak to the due diligence that you do on your side of things in the corporate world and what you look for?
So that's a great question, Quan. Um, I've had clients sort of define the due diligence process to me as the legal proctology exam of a company, because it's where an investor or a potential acquirer or other people who are researching the company really get up and look with specificity under a microscope at every aspect of the company, from its formation all the way through whatever state that it's in. Um, and due diligence becomes very, very important because, as I said, when you're raising capital, there are certain requirements that you have to follow. One of them is you have to give a disclosure document to anybody to whom you make an offer or who wishes to purchase your stock or your notes or whatever security it is that you're selling. And to the extent that there are material misstatements or misleading statements in that offering document, which can get picked up in the due diligence, that's a basis for a claim of securities fraud against the company. And if the information from that due diligence gets replicated as schedules to an investor agreement or an acquisition agreement, that means that the company's making representations and warranties to the purchaser of those securities or the purchaser of the company that those statements of the schedules are true and correct. And if they're not, then that can create a breach of representation issue, which can be very, very damaging to the company.
I can tell you, thank you, Ken. I can tell you on the side of IP, intellectual property due diligence, and especially in patent due diligence. One of the things that the startups are not too keen about, but it is very important, is the chain of title. For example, if the technology was from a university and then the company picks up on it and runs with it, there has to be a clear chain of title running from or rights, clear chain of rights running from the university to the company. And also, the other thing is, as inventors of the company, invent things. They by just the nature of patent law in general, if they are an inventor, um, automatically when they are listed as an inventor, automatically they will be the owner of that patent. It doesn't automatically get transferred over to the company. There has to be an assignment over to the company. And so, in doing a patent due diligence or IP due diligence, that's one of the things that we look for. And so, startups should be aware of this and be more keen of it because it could derail. We've had situations where we have three inventors, two of whom assigned it over to the company. And the third one is nowhere to be found. And the company is about to be acquired, and they're just doing the IP due diligence, and they need to have chain of title. And it's been years now, and they cannot find that inventor. What that means is that, well, the company is the acquisition partner is not going to be very willing to invest money. And this is why that third inventor who has not yet assigned to the company is a loose cannon out there. The reason is he or she, in this case he, can do anything with it, including selling his right to a competitor. So that's why you need to have the one of the things in IP due diligence for the company in getting ready for a look at by the acquisition partner is to have chain of titles in place and have T's crossed and I's dotted. JJ, what do you see along the line of due diligence? What are the pitfalls that you see that companies
Uh,
walk back?
yeah, let me. There is a question from Abby, so I'm going to answer that first, and then we'll go back. So he says, JJ, can you expand on the different funding levels and when a startup is ready, mature to move from a seed fund to a Series A, B, C? Um, so the definition of what the levels are of a seed, Series A, Series B, and or pre-seed has been changing over the years, and especially when it comes to life science or medical device startups. But I'll speak in general first about that. So really, it used to be if you're doing a pre-seed, for example, it's let's say it's 200 to $300,000, or if you before that you do a round of friends and family, and you raise a little bit of money to get things started, um, and then maybe seed it goes, let's say, $1 million, and then Series A goes into maybe 3 million and up, and then B, etc. But these levels have changed really over the years. Sometimes now I see seed companies raising 5 million,
Mhm.
or Series A of 20 million. So there are so there's I guess what I'm trying to say is there isn't really um, a range anymore. I mean, it's still there is a little bit, but it's really all over the place nowadays. It's kind of different to kind of pin it down. Um, for life science and medical device companies, it is a little bit of a different animal because for these type of companies, you need a lot more money in order to reach a specific milestone that is attractive to investors, attractive to someone who could acquire the company. So for life science or medical device in general, I want to say it is a little bit different because the pre-seed and the Series A and the seed are a little bit higher than the rest, and because it takes such a long time to reach a potential company that's potentially could be acquired, and usually, it's an average of 7 to maybe 15 years to reach that. So the dollar amount is usually higher. It requires more money along the way, sometimes in the tens of millions, in order to reach a potential exit. So multiple rounds of funding is needed for these types of companies, especially if you need some regulatory uh, work to be done, FDA approval, etc. That takes a long time, and so investors are always, for these types of companies. Again, they're looking for for the the team at the top of the list, but of course they're looking at the science, and usually there are certain types of investors that are interested in this area, and they do have potentially a long. They know that they have a long runway, sometimes 10 to 15 years before a potential exit. So I hope I answered the question, but it's not very exact. You can go ahead, Quan.
Yeah, so this is a question as a follow-up for Ken. Ken, so what I'm hearing from JJ is that the definitions have changed over the years, from seed to angels. Usually it goes from family and friends, and fools, family, friends, and fools. And then that's considered seed. And then you go to the angels, which runs about up to about $500,000 or so. And the checks that come in are usually in a $25,000, $50,000, even sometimes $5,000. And then after the angels, you have several rounds of that, to follow up. And then A series, B series, and so on and so forth, D. So question for Ken is there any legal implication as to each stage? Calling it a seed, are there legal implications attached to that? Calling it a series B, are there legal implications attached to that? And how does that, play into the cap table? Can you speak to that?
Yes, thank you, Quan. So I agree with JJ that the sort of ranges that used to exist really are not as important anymore, because a company is going to define the offering that it makes by the amount of money it needs to meet a particular purpose or set of purposes. And so the reason that we use seed or these letters is just to designate each individual round of financing that the company has gone out for. And we've had clients, as JJ said, particularly pharma clients, where they require so much money up front to get to a particular result that can get up to level H, level I stock. The big issue is that each one of these rounds has its own terms and conditions that layer over each other in the overall cap table. And so you really have to be careful, because you're giving successive rights and privileges and preferences to each of the investors as they come in. And the earlier they come in, the higher the risk they're taking with their dollar, the more privilege and more preference they're going to have. But every privilege and preference that you give is taking away something that a later investor could have. And so you really have to almost write it out and be very, very careful with the way that you spread out these things over the course of the projected financing requirements of the company going forward. And I think it's critical for startups to have somebody like a JJ who can sit down with them and say, from a financing point of view, if you're going to need to raise $200 million to get to product launch, then this is the way we should structure it. And these are the successive rights and preferences and privileges that we should be giving out as we go up the chain, so that it all works together once that overlay is there. Because I've seen companies get very, very skewed, and shareholder lawsuits will result where they sort of confuse or they forget what they've given, and they don't operate in that way with respect to each of the classes of preferred stockholders that they've raised funds from.
Wow,
JJ,
very,
I see that we have that's really good. Thank you, Ken. JJ, I
yeah,
see we have a couple of minutes left.
yep.
Perhaps maybe we each just have a takeaway message for the attendees today. Up to you.
No, 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 that's great. I just want to say one thing that's really important, and that is, when you're raising capital, the when you have especially multiple rounds of funding, um, and there are lots of investors involved, and you have early stage investors, and the ones that took the highest risk. One of the things that startups are not, they don't think about, they come and say our valuation is they're just starting. It's 50 million or 100 million, and they're not thinking that the investors are in it for the purpose of getting return on their investment. And especially early stage investors, most investors are in the same range. I would say they're looking for at least 10 times their money. So if a company, if most companies, let's exclude for now life science, pharma, medical device, but let's say most companies um, are exiting for 100 to 200 million dollars. So if you come to an investor and say, I have a $50 million pre-money valuation, then you need to exit for 500 million for that investor to get 10 times their money, because 90% of the companies um, end up you know not being in business in a few years. So so these investors are losing their investments. So the valuation needs to correlate with the stage of the investment. So if it's early stage, first time you're raising capital, seed, or whatever you want to call it, seed, pre-seed, etc., it needs to correlate with the investor's objective, so they could raise, so they're able to get the return on investment. Because from that 10 times that I'm talking about, they're really trying to cover for the nine that they lost. so
Right.
so that one is going to cover for the others. So it's really important to have the right valuation along the way. So maybe that's my takeaway. Quan, you go ahead, give your takeaway.
Yeah. So let me summarize your takeaways. The takeaway is valuation, right? It's valuation, and what I'm making a connection there is that at each stage, going back to Abby's question, at each stage, whether it's seed funding or angels one, two, three, and then series A, B, C, and so on and so forth, it's the valuation that you set at that stage and the terms and conditions that go along with it, which supersedes and dilutes out everybody that come before. Am I saying that right, guys? JJ
it's
and
gonna
Ken?
it's gonna dilute them, but along the way, each investor that's
Mm-hmm.
investing, they're
Mm-hmm.
looking for 10 times. So
Mm-hmm.
regardless of the dilution, it doesn't
Mm-hmm.
matter how much you're diluted, as long as the dollar amount at the end of the day ends up being
Right.
making sense. So it doesn't matter of the percentage of ownership. I don't think that matters as much as the dollar that's associated with the transaction.
Yeah. Wish we have some more time to talk about safe and all that stuff. But anyways, Ken, you're about to say something.
Yeah, no, I would say what also really matters is that you have you have put together a use of proceeds which tracks and sets the milestones for what an investor understands they're going to benefit, and the company is going to benefit from the receipt of that funding. Because if you tell an investor that if you invest X into my company, it will result in Y, and you only get halfway to Y, and now you've got to go back out for another round, maybe a down round, that's going to have serious consequences. And so you have to really be very careful on how you measure and tie up everything and perform what you say you're going to do.
All right, Quan, do you want to any last words?
Yeah, so I guess the takeaway would be two things. One is make sure that your the people that you work with for the company who contributes intellectually, if there's an agreement that the intellectual property or the patent or the invention belong to the company, make sure there's documentation of that, and the assignment has to be properly written as well. And there's a lot of case law on that. Have to use present tense, by the way. Email me if you have questions about that. Yeah. So the other thing is that there's it is not a myth. It used not to be. It's called a poor man's patent, where you write your invention down and you mail it to yourself, and it's so on and so forth, as proof that you thought of it first. Well, once upon a time, there was first to conceive. That was way back in the day, at least 10 years ago. That no longer exists. Now it's just like the rest of the world. Basically, you file first. That's it. There's no who thought of it first. So it becomes very important that that you file as soon as possible, not too early, not too late. Too late being that you're out there talking about it, disclosing it already, and especially for those companies who are interested in foreign filings, and those companies tend to be pharma, medical device, and so on and so forth. In the United States, if you speak about it publicly, speak about it, you have a 1 year grace period to still file a patent application on it. In other jurisdictions, Europe, China, Japan, etc., once you speak about it, tomorrow you are not able to file on that patent application to cover your invention anymore. So that's my takeaway message.
Well, there you go. So we do have a thank you from Albert and from Abby. Um, Thank you very much. So if you have any questions for Ken or Quan, their emails are right there. I should have my email as well. I'll type it in the chat. Um, but thank you all very much for being here. Again, this is our first inaugural broadcast here, and it's live. We have few people here, so we'll make it better. I know some people from the chat, they've had some issues getting on or seeing us, but they did. I think they heard us, or maybe they're seeing some of the chat. But there are some people that had trouble joining. It looks like. But thank you all very much, Ken. Thank you, Quan. Thank you. Hopefully, we'll do this again. Thank you for the audience, and
Thank you,
again,
JJ, for putting it together.
Yes,
no
thank
problem. And I put my email in the chat just in case you guys want to reach out to me. All right. Well, this is recorded on YouTube, so because of YouTube, it will be available in about 24 hours. So if anyone wants to come and to see this again, you'll be able to see it on YouTube. You could also, well, to go see it on YouTube, you could follow. Go to Pismo Ventures YouTube channel, and then you'll be able to see it there and follow us on YouTube as well. All right.
You want to make the announcement for the next round, JJ?
The next time we're doing this, it's gonna be we're gonna try to do this the second Tuesday of every month. So so let's plan on second Tuesday of every month, and hopefully everybody that's here will be receiving a notification about our next broadcast. All right. Thank you very much, and we will talk soon. And
Thank you,
I'm going to
everybody.
end the broadcast now.